Good evening, this is John Milburn, Laws 12067 Environmental Law. It's week 9, we're dealing with environmental litigation, civil law. In your text, it's chapter 17 and problems 20 and 21. At this stage, I expect to release the results of the first assessment piece on Sunday. I'm just waiting for a couple of late comers to submit their work, but the final cut-off is Saturday night. So at this stage, I've marked all the papers that have been submitted, and I'll expect to release those results Sunday morning. In terms of the second assessment, which is the Ella Bay Integrated Resort, there are some links that are now impossible to navigate, it would seem. So be resourceful. There's a discussion on UCRU about this. Have a look at the specialist reports and the summary, the executive summaries, and I'm sure there's more than enough material there that you can access that will provide you with sufficient material to enable you to complete the task. And I'll just get you to mute your microphone there, Tony, if you would. Now, in terms of the Ella Bay Resort, it's due, the assessment is due next Thursday, and the resort itself is 10 kilometres, or the proposal rather, 10 kilometres northeast of Innisfail. The proponent has a very nice website that you can access, some interesting material as well, some good photographs, but you'll see that it incorporates open space, a golf course, parkland, holiday villas, accommodation, so a whole range of different things, including permanent residence, and that's what this project is all about. You'll see through the reading, if you haven't already, that the whole project was declared by the Coordinator General to be one of significance under the State Development and Public Works Organisation Act of 1971. So the process of obtaining approval is very multi-layered, you would see that. So in your reading, you need to consider the Coordinator General's report, the power that the Coordinator General has to audit for development for compliance, and issues in relation to compliance, concurrence agencies' involvement. So it's an interesting task that I've set you, and I look forward to your assessment. But don't be too concerned if you find the material there, then I'm sure there'll be sufficient, even though you may not be able to access everything. Just a few comments about the exam. Excuse me as I just change some material. All right, so on the examination, it's in two parts. There's a compulsory question that's worth 20 marks, and the type of exam that I normally set in for the compulsory will require you to consider, you know, you're a first-year law firm, in a law firm for the first year, you're confronted with a particular situation, you're required to generate options, explain those options, possibly draft an advice, possibly draft a submission, possibly draft some basic pleadings, have a look at some of the pleadings in the material. It will deal with a hypothetical scenario. You can probably expect to be some sort of dispute associated with the matter. You might be acting for a proponent, you might be acting for a counsel, you might be acting for an objector. It may be a matter that relates to an application, or it may be a matter that relates to a compliance issue. It might be an enforcement issue. It could be a prosecutorial issue. So there's a whole range of different things that it could be within the context of litigation, but you can expect it will be court-based essentially. So it's not, there will be some town planning issues to do with it, but you're not required to have a detailed knowledge of town planning. With respect to the compulsory question, I'm really looking for your knowledge in relation to, well, pretty obviously, I guess, the Sustainable Planning Act and or the Environment Protection and Biodiversity Conservation Act. They're probably the main two, but you can't ignore other important pieces of legislation like the Environmental Protection Act. Do consider the context of the litigation, so think about practice directions, think about those sorts of issues as well. Always in your brainstorming for options, you need to consider alternatives to litigation, so clearly issues to do with alternative dispute resolution, as well as the application to a court, if relevant, is something that you should consider. Think about the cost ramifications. Think about expert evidence, participating in ADR litigation, things of that nature. So the first question, which is compulsory, is dealing with a factual scenario, and I'm trying to draw out from you your knowledge of different options and the way in which the legislation in particular interplays with each other and for that factual scenario. Now, the second part is where you need to answer, it's pretty basic, 3 of 6 questions. And each of those is worth 10 marks. So the compulsory question is worth 20 marks, and the part B, where you answer 3 of 6, is worth 10 marks each. So that's 30 plus 20 is 50 marks. So these are all essay questions. So there's short questions that provide you an opportunity to expand in your knowledge. Some of the things that you might expect, well, we've talked about kind of separation of powers in a fairly specific sense in this course, not a general sense. I'm not looking for an introduction to law type response, but in the context of environmental litigation, environmental decision making, you can see that Parliament, executive and the courts all have their role to play. There's also, of course, the distinction between state and federal, and of course federal and international. So we've talked about international treaties, how they come into existence, are they enforceable at a domestic level? If not, how do they become? All those sorts of issues are what I would regard, the separation of powers issues. Who's got the power to do what? Who's got the power to enforce in an environmental law context? The other things that you might think would be relevant in the examination, I guess things to do with sustainable development, ecological sustainable development. What does that mean? Where does it come from? What are the components of ecologically sustainable development? Precautionary principle, intergenerational equity, things of that nature. You could probably expect there might be something along those lines. We've talked a lot during the course of merits reviews versus judicial review. So you really need to understand what a merits review is all about. Given that almost all the cases in the Planning and Environment Court are merits review based, probably not too hard to work out what that's all about. But just keep that in mind as what we're talking about. All right, so coming back to what else there might be. Well, we talked about IDAS, but it probably won't be a general question about what does IDAS mean. It won't be that broad. I'll probably zero in on certain aspects of IDAS. We've talked about issues to do with impact assessable development. We've talked about the role of concurrence agencies, assessment managers, those sorts of things. So whatever it might be, think about IDAS, but expect it to be a little narrower than just to tell me what IDAS is all about. You might think about, well, we talked quite a bit about environmental impact assessment and statements. We had the guest speaker, Phil Jeston, so there might be something about that. But at a state level, at a federal level, the interplay, bilateral agreements, talking about significant projects, etc. So there might be some issues to do with environmental assessment. We've talked quite a bit about the assessment process contained in the EPBCA. Again, Phil Jeston in that context. And of course, we had the excellent Sean Ryan's discussion in relation to issues to do with the Land Court, the Planning and Environment Court, issues to do with standing, difficulties associated with community litigants and environmental litigation generally. So Sean's discussion was excellent about all of those issues. What are the issues? How do we deal with those? What sort of advice can you give? Possibly to a proponent, possibly to a counsel as an assessment manager, and possibly to a submitter or an objector. And then, of course, next week, we haven't covered criminal law yet, but there will be criminal law next week and challenging environmental decision-making and ADR the week after that. So you can expect that there may be questions that are drawn from those topics as well. Now, there won't be any substantive material in week 12 Week 12 is really review, and it'll be general questions, so I'm open to any discussions that you might have. So the purpose of that little discussion was to give you an overview in relation to what might be on the exam. Having said that, you know it'll be in two parts. Part 1, compulsory, 20 marks. Part 2, 3 of 6, essay-style questions. Now, if there are any questions about that, please let me know. Otherwise, use the chat facility or come in live. So that's what the exam is all about. Okay, so now if I could just...
Yeah, can I ask a question?
Yes, Tony?
Is there any old exams, example exams, we can have a look at, or is just the questions at the end of each week enough to...
That's actually a good question, because this is the first time that this particular course has been offered, and I had the privilege of writing the material and presenting the first course, which is great. Having said that, I've presented other environmental courses as well, so I'll give some thought to that as to whether I might provide some sample questions for you to consider. All right, but thanks, Tony.
Yeah, thank you.
Any other questions about the second assessment piece or the exam? All right. Well, I might move on then and perhaps discuss the questions for this week, the problems for this week. Problem 20 dealt with the issue of standing. Hopefully you've had a look at that, provided some comments or notes for yourself. So the question concentrates on, I guess, the limitations that apply to an objector in relation to a merits review. So not every decision that is environmental based allows an objector to go to court and make a case against it. So there are some rules that limit standing, and there are limitations in terms of what type of decision can be taken to P&E court. So impact assessable development, for example. So think about the processes and the expenses associated with litigation or standing in environmental litigation. And when it comes to looking at this question, the question, of course, is it's all very well extending standing to environmental group or even any person to enforce laws, but the ability for objectors to lodge merits appeals is restricted. There are costs associated with it. What are the problems that challenge people in environmental decision making? And it will remain a privilege of the rich. So this is the discussion point that we're talking about. So I've talked about the issues to do with getting your foot in the door. But if you were considering this type of question in an exam context, that's not meant to be a specific hint, but just in general terms, Tony, to answer your question, probably the essay style questions will be similar to the weekly questions, but probably a little easier, if I could use that term in a general sense. Anyway, coming back to this problem 20, I guess you could talk in terms of what are the policy issues behind standing. There's the enormous debate that's going on at the moment in terms of the changes to standing regime at a federal level. So is the concept of standing necessary from a policy perspective? Should the court and tribunal talk about the legitimacy of the claim rather than the attributes of the claimant? In other words, why are we even talking about whether this person should bring the claim? Let's concentrate solely on what the person has to say about the claim. There are issues to do with costs, security for costs. You may have come across that term, which is where a litigant is required to essentially provide a guarantee for payment of costs in the event of loss. So how do the costs awards in legal challenges differ from awards in merits appeal? Are the rules justified, etc.? So, you know, and would it be, just from a policy point of view, would it be useful if people knew upfront what their costs might be before they start, rather than say, be confronted with advice from a lawyer to say, well, the cost could be very substantial. What are the costs? And the lawyer might say, well, how long is a piece of string? You know, that's not really very helpful advice. You know, it may be that the lawyer says, well, the cost could be $50,000, but they could be $500,000. You know, it doesn't really help in decision making. All right, so if there are any questions or comments about problem 20, please let me know. Otherwise, I'll move on to problem 21.
Yeah, I got another question
Yes,
for you.
Charlie.
With, in New South Wales, anyone can claim standing, right, in an environmental thing.
Yep.
Why is that?
Policy
Because,
decision.
hey?
Yeah,
Is it?
it's a policy decision, and it really comes down to the question of the Parliament, I guess, coming to the conclusion that it is appropriate for any person to be in a position to embark on a legal challenge.
Yeah, but the problem I see with that is you can have someone that lives 2,000 or 3,000 kilometres away, and they can put in a claim against something because they've jumped on a bandwagon or something and said, someone that lives there, where the environmental issue is. And, I just think that's ludicrous that someone that hasn't got any, they don't have any standing, in the thing. And I suppose it's just the way the politicians dealt with it at the time, was it?
Exactly, and it's a policy issue, and the Planning and Environment Court goes to pains to say on a regular basis that the court is not there to determine policy. So the issue about standing and the opportunity for anyone to initiate environmental-based litigation really comes down to that policy at parliamentary level. But it's an interesting debate.
Sorry, John, I just have something to add there that Tony's mentioned. I work in the Bowen Basin in coal, probably not the best thing in environmental law, but he's talking about standing now. If there's Hay Point and there's all that kind of stuff happening now, and they come from far and wide applications, saying, against it or even, supporting it. But I mean, they come from a long, long way away for that, for standing, because it's such a I don't know, important important thing. But yeah, they come from everywhere in Queensland to protest or dispute that kind of
Absolutely.
development.
Thanks, Shane. And I think it's fair to say that at the moment the standing rules are quite broad. As I said, the Attorney General at a federal level, Senator Brandis QC, is looking to restrict that entitlement to challenge. So thank you for that contribution, Shane and Tony. Are there any other comments? Michelle says, on the other side of the coin, the person without standing may have the funds to pursue the matter where those with standing may not. So in the sense, it's an ability to offer wider access to justice. So there are certainly different ways to look at this issue, and I think it's just a fascinating discussion. So thank you for everyone to contribute there. And please feel free to jump in and make any further comments as we progress. All right, moving on briefly now to problem 21, which deals with enforcement of environmental laws, regulatory perspective. The question is, regulatory authorities may enforce environmental laws in a different number of ways, or a number of ways. Discuss. Well, they might. So I guess when it comes to enforcement, given that I practice primarily in criminal law, the first thing you think about is prosecution. And that's very important. But it may not be the most appropriate or the easiest or the most beneficial for a regulatory authority, I should say. For example, civil action carries with it substantially more costs. So that may be seen as a greater deterrent. The onus of burden of proof is different too. So the onus of proof, or the onus of proof on balance of probabilities is much easier than it would be to establish them beyond all reasonable doubt. And Tony says you can't put a company in jail. That's true. Although, think about the obligations of a director, and it may be that the directors are personally liable. So fining may be a better option. The penalties which courts which impose might generally be regarded as being at the lower level, although there have been some very substantial magistrates' court penalties imposed. But the courts may arguably think more in terms of the mitigation aspects and may regard the crimes as victimless. So there are a few issues there in terms of regulatory authorities and the options that can be generated. So think about that. I'm not saying that's necessarily an exam hint, but that's the sort of question that you might expect in the exam, in the essay style of the exam, coming back to Tony's earlier point. All right, so if there's any questions about that, please let me know. In terms of the content of the text, have a look at chapter 17, as I mentioned earlier, and in the notes that I've provided, you'll see that there is some commentary in relation to the possible repeal of section 487 of the EPBCA, and some commentary there about the Environmental Defender's Office in New South Wales, having some concerns about that. I've provided some sample cases in relation to the issue of standing, and I made a comment earlier that the exam may require you to do some simple drafting of pleadings. Have a look at 4.4, which provides a sample merits appeal by a submitter. It's only a skeleton, but it provides you with an idea of what it is that you must consider if initiating court proceedings in the P&E court in relation to objecting to a particular development. The other thing is, have a good working knowledge of the steps in the Planning and Environment Court. So today's talk is about civil law, it's environmental litigation. So let's assume that someone wants to initiate proceedings in the Planning and Environment Court. What are the steps that we need to follow?
Just before you go on, John, what was that section of the EPBC Act again?
487.
Yeah, and the pleading?
Oh, the pleading, in the notes, I think it's, let me have a look. I think it's 4.4. 4.4
okay.
My notes, is that right? Okay. All right, so thanks, Tony. So if you wish to initiate something, a court action involving environmental litigation in the P&E court, what do you think the first document is? What's the first step? Anyone got any idea? Application, yes. The application. What do we call the application to initiate proceedings in the P&E court? Appeal, notice of appeal. That's it. Thanks, Michelle. All right, so file a notice of appeal at the registry. There are time limits, of course. Have a look at those time limits. Have a look at the website for the Planning and Environment Court. That will provide some very valuable information. And of course, the Sustainable Planning Act sets out all the time limits that apply for the appeal process. So in terms of what I said about what might be in the exam, these are the sorts of things that I'd like you to pay particular attention to. All right, so you've filed your appeal, you've done it in time. What do you have to do next? What's the next step? Appeal must state the grounds of the appeal, yes. So that's exactly right. And then go back to 4.4, and that sets out sort of in a skeleton form what needs to go in the appeal. But once you've completed your appeal, you've set out the grounds of the appeal, you've filed your appeal in the registry, what's the next step? Assuming you've done it on time, of course. Outline of arguments? No, not quite. It's a pretty basic one. It's almost a trick question, sorry. I'll give you a hint there. So you've filed your material, I'll give you a hint here, you've got your service copies. So you file your material in triplicate or quadruplicate. The court stamps, tell the other party. What do we call that process of telling the other party? What's the official way of doing it? Service, thank you. I can tell you a story from my very first week as an article clerk. I think it was my first day. I accompanied the partner that I was articled to I think it was federal court litigation. It was pretty high powered. My partner said, "Here's material, file that, serve that on the other side." Well, serve the other side, does that mean offer them a drink? But I worked it out. So I walked up bravely to the other side and say, "I served this material on you," made sure I knew who I was serving, got the date and the time, recorded that on my copy of the material. So I was able to swear an affidavit to say, on this day, at this time, at this place, I served this person with this document. So service is important. So you've got to serve the other side or the other relevant parties to the material. So
is there specific words you got to say?
What was that, sorry?
Is there specific words you got to say to them?
No, I don't think so. You watch the TV and they'll say, you know, regard yourself as served or whatever, but no, I don't believe there is any specific word. But it's just a matter of ensuring that the person that you speak to is clear that you are affecting the process of serving the material upon them. So there's a few comments coming in. Have a look at the UCPR. I agree with that. There is an affidavit of service, and that's what I completed an affidavit of service, coming back to that story, what happened to me on the first day of my articles, based on the notes that I'd written where I could see the time, the date, the place and the person. And that's all incorporated into the affidavit of service. Exactly right. Okay, so we're working our way through this process, this practical process of getting our litigation underway. We've completed our notice of appeal. We've put the grounds of our appeal in. We have, within time, filed our notice at the registry. We've obtained our service copies. We have now effected service upon the other side. We've completed an affidavit of service. We've filed that affidavit of service. What happens next in P&E litigation? What's the next step? Outline of argument, not quite. We'll get to that. Sorry, Michelle. Not quite. We have to go through a bit of a process. There are certain steps on the way through, and usually that requires attendance at a call over, or in the context of planning and environment court litigation, an application for what we call a directions order. So usually a court will provide directions as to the future conduct of the matter. So the party that's making the application, I mean, let's say it's the developer, applies for directions within 3 months of the notice of appeal being filed. Have a look at the UCPR provisions, have a look at the provisions in the Planning and Environment Court rules, and just acquaint yourself with those practicalities. Because as a first-year lawyer, these are the sorts of things that you might need to do, coming back to the exam question. So have a look at the Form 4 application in pending proceedings. It's filed in court, and the matter will then come before a P&E judge. Okay, and then having applied for directions hearings, we then need to appear before the court in order to obtain these directions orders. So the directions order comes about as a result of appearing at a directions hearing, and in the directions order, the judge will set out the process, the time limits, the process, what's going to happen. Now, usually these things are discussed, of course, by the parties, by the litigants, before going to court, before going to the directions hearing, and quite often the parties will say, by consent, Your Honour, we hand up draft order by way of directions, and the court, if satisfied, will then say, yes, I will now make that an order of the court. Usually in planning and environment court litigation, there is an emphasis on alternative dispute resolution, and the ADR process is administered through the ADR registrar in Queensland, and the ADR registrar will usually require the parties to attend some sort of without prejudice conference, and the parties are required to attend the conference participate in that ADR process. Now, following that, there will usually be some sort of review hearing. The parties are expected to attend the review hearing. The court will want to know if parties have complied with the previous directions. If not, why not? Are there any matters that are outstanding? Are there any issues that have arisen that were not considered at the original directions hearing? So in that review hearing process, the court is really asking, what have we done? Have we done it on time? If not, why not? Have new issues arisen? Do I need to provide further directions for the conduct of the matter? Otherwise, all done, dusted, we've done the ADR, we didn't settle, okay. Ladies and gentlemen, are we ready now for the final hearing? So essentially, during that review hearing process, the court will order perhaps the matter proceed towards a trial. And, you know, we have this ongoing as this process of callovers. Callovers are really essentially where the court says to all the parties, please attend at this time. I want an update. I want to manage the list, try and work out what matters are going to happen at what time. Tony asked an excellent question. Is there disclosure involved in that? And the answer is yes. And that whole process of disclosure is part of the directions hearing. So part of the directions will be do this, do that, disclosure, experts conclave, for example, if there's going to be a meeting of the minds of the experts. So all those sorts of things might be considered in a directions order. So do try and have a look for a directions order. Now, have I shown you the way in which you can go to, and I'll come back to it actually, I'll come back to this, because I'm almost finished the procedure. So we have this call over. At the call over, the court says, all right, well, we're ready to go on this case. That's number 1 on the list. That's the one that I'd like to hear first. So I'm going to allocate, you know, whatever it might be, May 7, this matter, here is day 1, and I allocate 2 weeks for the hearing of this case. So that's usually what happens at the tail end of the call over. Okay, so in terms of actual documents, have I shown you, call overs are quite quick. Well, sort of yes and no. The actual mention of a particular matter at a call over can be quite quick. But, you know, call overs can go for a couple of hours as well. And it just depends on the nature of the call over and the number of matters on the list. So if you've got 50 matters on the list, and a call over is really just where the judge says to the legal representatives on the record for all the matters on the court list, look, essentially, people, I'd like you to attend at this time on this day. You don't need to worry about bringing your clients, legal reps only. I want to work my way through the list and find out what's going on, and essentially, for want of a better term, create a batting list, a batting order for the sittings that are coming up. So, you know, I'll say Judge Rackerman, for example, may say, I have sittings in Mackay commencing on the 1st of March 2016. Judge may say, I wish all the parties to attend a call over on the 12th of February and at 9:45 a.m. You can appear by telephone or whatever it might be. And essentially there'll be a list of all the matters before which are involved in the Mackay sittings that commence on that day, and the judge will just work his way through, in this case, his way through that process of finding out what's going on for each of those cases. So that's what a call over is all about. Now, have I shown you the court on the court's website? And please, I'm just going to share the screen now. Correct me if I have already shown you this. You should be able to see my screen. If I can just have a thumbs up, and you should see the court's website. Tell me if I've already shown you this, but let's see. Search civil files. So we've done a search of civil files. Party search, for example. This is great because it actually gives you precedent documents. So let's say from where I am, given party, Fraser Coast Regional Council. So we'll type that in and search for there we go, 0. No, that doesn't seem right. Try again. Maybe if I pop it in there, that might be better. Search. Have I shown you this? All right, doesn't matter. Come on. Oh, I'd love to have the NBN. That would be great. I just find at this time of evening, it gets a bit slow in my neighbourhood. Waiting. Right, now we're into results for Fraser Coast Regional Council. And I'm looking for a planning and environment court matter. So there's personal injuries. Here we are, planning and environment court, Walter Elliott Holdings. So let's have a look at the file details for this case. Do a search and you can see here the actual documents. This is great. This is a great website. So let's have a look at the originating application. Which is just loading now, opening in 10 seconds. Sorry, my internet is slow. And there you can see the actual document. So if you want a precedent originating application, then that will give you a good precedent. And it sets out there, you know, I said previously, it was in 4.4 was the skeleton. Well, here's the skeleton with some fleshed out a bit. So that gives you an idea of an actual document that was lodged on the 13th of October 2014 in that particular case. So have a look at that. It's got some wonderful material. There's Judge Malzone presiding in that case. And there's an application to the Court of Appeal. That's an interesting document. Application to the Court of Appeal. So that's what was filed in that case. Okay, so play around with that website, have a look at some documents, and it will give you a really good idea of not only how to prepare the documents, but also how to the order of the documents as well. Okay, are there any questions arising from any of that? Thanks for your patience. I'm sorry for keeping you a bit with things being slow. I think we've just about got to the end of what I wanted to talk about tonight. Unless there are any questions, that's probably all that we need to worry about until next week. Okay, so no questions? Okay. Well, thank you very much for your patience tonight, and I'll stop the recording now. All the best.